Well, good evening, everyone. My name's Catherine Barnard, and I have the great pleasure of introducing to you this evening Jonathan Jones, who was former Treasury Solicitor and Permanent Secretary of the Government Legal Department. Now, it must be said, when I was talking to him before about how I could introduce him, all of this is tremendous, but in fact, he has acquired superhero status, and it's quite rare to say that about lawyers. Lawyers normally have such a bad press, but superhero status for actually standing up for what he believed in and what he believed was in the code of conduct and ethics for over the way that the government were behaving over the internal market bill, over the clauses there, where, as we know, Brandon Lewis said, they were breaching public international law, albeit in a specific and limited way. Now, Jonathan's got a huge amount of experience inside government, in particular in the context that we're talking about, involved in negotiating the text of the withdrawal agreement, the divorce text from the EU. I'm going to hand the floor over to him. He's going to talk for 20-25 minutes and then has very kindly agreed to take questions. And if you've got questions for him, could you put them in the Q&A box, and Marcus and I, between us, will field those questions. Just please note that this session is being recorded, so it will be publicly available. But Jonathan, thank you very much indeed for your time, and we really look forward to hearing from you.
Well, thank you very much, Catherine. Thank you for inviting me. And I mean, really, after an introduction like that, I fear I can only disappoint, but I'll do my best to live up to superhero status. How embarrassing. I agreed I talk on the topic of challenges for the law post-Brexit, which felt like a sufficiently wide topic, which would enable me to say anything I liked. I won't breach any professional confidences. I hope that isn't too much of a disappointment, but I wouldn't do that, as you might expect. But I am going, obviously, to share some of my reflections based on my experiences of working for government, including for the last 6 years or so as Treasury Solicitor and head of the Government Legal Department, over what obviously was a rather interesting period, and also on my reflections on what's now in the public domain and what's happened since I left the civil service a few months ago formally, where I don't have any secrets to impart, but nonetheless I am following, like the rest of you no doubt, what is happening. And the good news, I think, for us is that there's a load of law. Brexit has generated the biggest changes to our legal order and the most complicated set of legal instruments, international law instruments and domestic law instruments that I think I've probably ever seen in my professional life. So there's plenty for us who are lawyers or future lawyers or people who are interested in the law. There's plenty for us to get our teeth into. That's the good news. But I was asked to talk about the challenges. And the first challenge, I think, for the country, for politicians and for lawyers, for all of us really, is to come to terms with the fact we have left the EU and with the deal that has been reached and with the law that has generated. And let me explain what I mean by that. And speaking as a lawyer now, my view on whether Brexit was a good idea or whether the deal that was reached is a good deal or not is irrelevant. We've left, we've got the deal we've got, and that now represents the law, which has to be applied and interpreted. And by that, I mean both the withdrawal agreement, and I did have some involvement in negotiating certainly the version of the withdrawal agreement that was concluded when Theresa May was Prime Minister. That version, of course, did not find favour with Parliament, and therefore another version was negotiated, and you may have your own view as to how far that really differed from the Theresa May version, but it was different. And that version, of course, under Boris Johnson as Prime Minister, was approved by Parliament, and that's the version of the withdrawal agreement that was concluded in October 2019, and that's the version we've got. And that was implemented into UK law by the EU Withdrawal Agreement Act 2020, And of course, that includes the Northern Ireland Protocol, which continues to have effect, despite the fact that the UK has now left the EU, and indeed the implementation period has ended. So that's one part of the deal. And then the other part, of course, is the new Trade and Cooperation Agreement, the TCA, with which I didn't really have any involvement for various reasons, which I may come back to. But certainly lawyers in my department were very closely involved in negotiating it. And that Trade and Cooperation Agreement was, as you know, concluded just before Christmas and was given effect into domestic law very quickly in the EU Future Relationship Act 2020, although not yet ratified, by the way. We may come back to that too, but that is the deal. And those agreements, both the withdrawal agreement and the TCA, are binding on the EU and the UK under international law. In the case of TCA, they're provisionally binding pending ratification, but let's park that point for the moment. They are international law instruments. They are part of the law. And in different ways, they have both been recognised, let's say, to use a neutral term, by Act of Parliament, recognised in UK law. So in the case of the withdrawal agreement, including the Northern Ireland Protocol, by that recognition took the form of something akin to direct effect by way of a provision modelled closely on Section 2 of the European Communities Act 1972. So the withdrawal agreement and the provisions that it made were given effect in UK law in that way. In the case of the TCA, by a different and quite complex set of measures and powers under the Future Relationship Act, of which perhaps the most striking is Section 29. Section 29 provides that UK domestic law, I'm slightly simplifying, but essentially it says UK domestic law must be interpreted and applied with such modifications as are necessary to comply with the UK's international law obligations under the agreement, under the TCA. And whatever view, that's not without controversy, that provision, but whatever view you take of it, it certainly recognises the binding effect of the TCA and provides for that to be recognised in domestic law, and indeed for domestic law to be interpreted so as to conform with it. Now, so all this is quite complicated. I have to confess, I don't claim to have mastered every detail of this. I hope that isn't too shocking to you. Many of the implications of the deal, of course, are still being worked out. It's also the fact that parliamentary scrutiny of the deal, certainly of the TCA, was extremely limited. And understandably so, necessarily so, given the timing of the deal just before expiry of the implementation period. Some parliamentary scrutiny is still going on now, essentially after the event. But I fear what this means is that the legal implications of the agreement are not well understood by many people, including at least some of the politicians who agreed to it and endorsed it. Now, sort of a month and a half in, early signs are pretty mixed, to say the least. Some teething troubles were inevitable, I would say, but in some cases we are, in my view, we're seeing simply the inevitable results of the agreements which have been reached beginning to work themselves out. And that's why I say the first challenge in the law post-Brexit is the need to come to terms with the very law which Brexit has created. And that's the law that now applies, for better or worse. And both the agreements, both the withdrawal agreement and the Northern Ireland Protocol and the TCA, contain their own provisions for resolving concerns and for settling disputes. And it's not at the moment really clear, at least to me, whether the kind of concerns that we're seeing with operations of aspects of the Northern Ireland angle to this, whether they are disputes. which will end up going through the dispute resolution procedure, or whether they are just concerns about how the agreement is operating, which could be looked at in the joint committee. But either way, both the withdrawal agreement and the TCA contain mechanisms, quite complex mechanisms, for doing those things, for resolving concerns and disputes. And no doubt they will be invoked. Some of them are already starting to be invoked. And of course, also in time, there's the possibility of negotiating changes to the agreement. And actually, the TCA does contain mechanisms within itself for making changes to it. And in time, who knows, even completely new agreements. And plenty of people think that we will be in continuous negotiation with the EU for the foreseeable future. But either way, making the existing agreements work or agreeing changes to them is going to require the agreement of both sides. And in some cases, some types of change, which are already being contemplated, would require changes of policy or approach, either by the UK or by the EU or both. And for good measure, both the withdrawal agreement and the TCA contain provisions for terminating the agreement. Again, I'm oversimplifying, but there are ways in which the agreement could come to an end in different ways. But until any of those things happen, the law is as contained in those agreements as entered into by the government and in the relevant domestic law that I've touched on, enacted by Parliament. So probably all of that seems very obvious, and I'm sorry if I seem to have laboured it. But from the pronouncement of some politicians, at least some politicians, you might be forgiven for thinking that everything is still all up for grabs. That if things don't turn out as people hoped, the government can insist on changes, certainly asked for various accommodations, or even decide for itself whether and how to give effect to the agreements. And whatever you think of that as a policy approach to the consequences of Brexit and our ongoing relationship with the EU, which presumably we will continue to want to have, this is a dangerous approach, potentially dangerous approach from a rule of law point of view. The idea that the government, if things don't turn out right, can decide what it's going to do about it, ultimately, unilaterally. Because as I think I'm saying, ultimately, the implication of that is that the government or the sovereign UK Parliament, at the government's behest, could decide unilaterally to alter or set aside the bits of the deal which it doesn't like. That, I think, is the implication. It may be more than an implication of some of the rhetoric that we see around particularly the Northern Ireland Protocol. And of course, the government has form here. So, and this is what Catherine was touching on at the beginning. I'm trying to avoid every talk I give or interview I give being about my resignation, because it does risk becoming a bit boring. I sort of risk boring myself, if I'm honest. But this is, it is worth just reflecting. This is what the government did in the Internal Market Bill. It asserted that it was constitutional and lawful, those are the terms that the government itself used, for Parliament to set aside aspects of the Northern Ireland Protocol. And again, I think as most of you know, some of you know, I disagreed with that view, and that's why I resigned as Treasury Solicitor. Quite a lot of other people disagreed with the government on that as well, including most of the House of Lords. Eventually, the relevant provisions were dropped from the Internal Market Bill, but the government has never accepted that there was anything wrong with them. So I think, I've said this elsewhere, I hope we're not going to go down that road again. But I do still think we are in a potentially unstable place in terms of the legal effect of Brexit and how they are understood and accepted, including by the government, if I'm honest. So that, I think, is, if I also talk about challenges, that I think is the big overarching challenge arising from Brexit, is how we approach the law which Brexit itself has created. But I want just to touch on a couple of wider challenges, not arising directly from Brexit, but forming part of the wider context. First of all, COVID. And here again, aside from the huge societal impact that COVID's had, obviously, still having, it is also a big deal legally, not least for my former department, for government lawyers. Obviously, we have seen the most intrusive, stringent controls in modern times, introduced almost entirely by statutory instrument, typically with almost no advanced parliamentary scrutiny, and actually typically with very little after as well. In some cases, major changes in the law have been made with as little as an hour's notice between finalisation and publication of the law and it coming into force. I think I'm right in saying the latest regulations on hotel quarantine have been talked about for months, this policy, but the law itself was only finalised on Friday to come into force on Monday, i.e. yesterday. So again, we saw major changes in the law introduced at very short notice. And I'm not implying any criticism at all of my former colleagues in the civil service who've been working so hard to respond to the exceptional demands of the pandemic, but including, of course, the government lawyers who have to draft the relevant legislation, often at very high speed, even overnight. And I also do understand that exceptional circumstances, we're dealing with a national emergency, that may require an exceptional response. And sometimes things have to be done differently and urgently. But I don't think this is a sustainable way of making law or policy, actually. And again, I've said some of this elsewhere. I do fear that the government is getting into bad habits. Just because the government can legislate in this way doesn't mean it should become the default approach to legislating on COVID or anything else. And the reason I say that is that, first of all, if at a really quite basic level, if people can't even find or read the law until hours before it comes into force, and we're not talking about technical provisions here. These are major laws affecting every citizen, every business, all aspects of our national life. If you don't even know what the law is until, as I say, hours before it comes into force, this risks causing confusion, obviously lack of certainty at what the law actually says, confusion on the part of users of the law. And I don't kid myself that every citizen is gagging to read a statutory instrument, but that is where the law is, and there will be people who need to know it, businesses and those who advise them, but also those who enforce the law. And if this is only appearing at the last minute, that does not help those people, those users of the law. And we've seen, for example, different police forces taking different approaches, inconsistency between law and guidance, and frankly, just an impression sometimes that policy and law are being made on the hoof. None of that promotes confidence in the law or in the process of lawmaking, precisely when understanding of the rules and compliance with them is so important, potentially a matter of life and death. And then secondly, why does any of this matter? The lack of parliamentary scrutiny, at least advanced scrutiny, mean that the substance of the decisions the government is making, and of course I readily accept that the judgments are really difficult ones, having to balance the need to protect public health with the impacts on people's lives and freedoms and on the economy. These are very, very difficult judgments, but they're not being properly debated, at least not in Parliament, and certainly not until after the event. And I just don't believe that's good for the quality of policy making and decision making. It doesn't lead to the best judgments being made, and it doesn't, of course, secure buy-in to those judgments from MPs and the constituents they represent. So maybe this is a political point. I don't know. It's not intended to be a party political point, but I don't think this is just good for striking the right balance between Parliament and the executive in the way that policy is made in such a contentious and intrusive area. So again, really the point I make there is that just because the government can make policy in that way, and indeed make law in that way, it has the relevant powers, it has a significant majority in the House of Commons, it can do these things, doesn't mean that it always should. And that, I think, has potentially wide implications for policy making and lawmaking generally. And then, so a linked point, I suppose probably my final sort of wider point, is about the way that laws and policy and decisions are made, and how the government is held to account for them, is this. So I commented on the lack of parliamentary scrutiny in relation both to Brexit and COVID. We also know that the government is looking at the ways in which its decisions and policies are scrutinised by the courts. So first of all, we have the independent review into administrative law, which is examining, let me get the quote, whether the right balance is being struck between the rights of citizens to challenge executive decisions and the need for effective and efficient government. So that review is going on. Again, I'm not giving away any secrets because I don't know any. It hasn't yet reported. My former department, the Government Legal Department, handles tens of thousands of cases of various kinds against the government, including many judicial review challenges to particular decisions and policies. Very broadly, I don't have the stats in front of me, and there are different ways of interpreting them inevitably, but overall the number of JRs against central government anyway has not markedly increased in recent years, I don't think. Most of those challenges fail, and that hasn't changed significantly either. Obviously, there can be no objection to the government examining how JR is working and whether there can be any improvements. And it's also human nature that ministers are sometimes irked when their decisions get challenged, particularly when they lose. And my former department, GLD, fights these cases on behalf of the government. It fights them to win, and is glad when it does. But so that's the law working itself out. But my view, I don't suppose this is really controversial. The courts, the role of the courts here is completely non-negotiable. The role of the courts in identifying and enforcing the legal limits of government action, that's fundamental to the rule of law, in my view. So I don't think that's contentious, probably not with this audience. It may very well be possible to make changes and improvements to the way JR operates. Personally, it's just a personal view, I am pretty skeptical about the possibility or indeed value of codifying administrative law, but we'll see. My own view also is that any attempt seriously to restrict the possibility of challenge to government action is likely to fail, frankly. I mean, all powers, however they are cast and whatever the statutory structure you put around their exercise, they must have their limits. They must have legal limits. And in the end, it must be the job of the courts to determine those limits. And as you all know, history suggests that attempts to prevent the courts from doing that do generally fail. But anyway, I include that as a challenge because until we know what the independent review says and how the government responds to it, we won't know how big a change this represents to our system of law and indeed our constitution. But it could be very significant, and it's significant that the government is looking at it. And then if you add to that the Independent Human Rights Act review, which is considering, again, I quote, sort of doing what it says on the tin, how the Human Rights Act is working in practice and whether any change is needed. And again, we don't know what that will conclude. But again, plainly, any significant change to the Human Rights Act is going to be potentially important for our legal order. And some of the things I've touched on, the relationship between public authorities and the citizen and the courts. So all of this is in play. Sort of looking at the time, I sort of feel I've really only scratched the surface. But my summary point then, which you may want to test or broaden in Q&A, is that the legal challenges brought about by Brexit, again, leaving aside the policy and the economic and other, still hugely contested policy, economic, the wider implications of Brexit, that the legal changes brought about are really the most significant changes we've seen to our legal system and our legal order. As I've said, certainly in my professional lifetime, we've barely begun to understand them. And then if you add to that COVID, again, focusing on the legal aspects of COVID and its effect on the way that the law is being made and applied, and then the government's policy agenda on administrative law and the Human Rights Act, I think it's fair to say this is a pretty challenging moment for the country and for the legal system and for anybody that's interested in those things. But of course, I also think, I hope, it's also quite a fascinating time for lawyers anyway. So there I will pause, and I'm very happy to take any questions. Thank you very much.
Well, thank you very much indeed. That was absolutely fascinating and rich and deep. And at least you ended on a positive note. We do try and say to students, despite you may be despairing at times, because we know how difficult it is to be in lockdown and not being back in university and enjoying time together. Actually, the studying of the law at the moment is absolutely fascinating, if endlessly complicated. And it's reassuring to me to hear you say you'll find it difficult, because I must say I really struggle, and it feels a bit like whack-a-mole. Just when you think you've maybe mastered one little corner, then something else is pops up that you hadn't even thought about.